Joe Biden is actively erasing women. Major changes today to Title IX protections for women. The Department of Education under Joe Biden announcing this today, that would erase the category of biological woman entirely. So being a woman really doesn't really mean anything. For more on this, I want to bring in Sarah Parshall Perry, Senior Legal Fellow at the Heritage Foundation and former Senior Counsel at the United States Department of Education. Sarah, good to have you with us. Thank you so much.
Thanks for having me, Vince.
Give me a sense of what happened here today. How monumental is this?
Well, it will completely upend and change the entire state of American education. That is not, I believe, an overstatement. This has just expanded protections for the sexes, male and female, as they've been understood for more than 50 years, to include sexual orientation, pregnancy or related conditions, and importantly, gender identity. Now, we know Title IX was sort of the crowning achievement of the feminist movement, right? So this was, they got work equality, failure to sort of have to suffer discrimination within an employment context. And right after that, on its heels, came Title IX of the Education Amendments of 1972. This was really something that was pushed by a lot of Democrats, a lot of progressive lefties at the time, Gloria Steinem, Bella Abzug. These are individuals who really wanted equality. We as conservatives thought it could lead to worse things. And today, one of those worst things came into being. That means that every opportunity, space, private space, bathroom, locker room, housing accommodation, scholarship opportunity, including athletics, is now open to men who identify as women but want to overtake women's opportunities.
So when they say they're expanding protections to include men, if they're expanding protections for women to include men, what they're really doing is they're stripping women of protections.
Oh, 110%, which is why it's almost laughable on its face. I mean, this is a civil rights law that actually violates civil rights law. It actually turns Title IX's scheme that talks about the two sexes, male and female, parent, mother and father, son or daughter, all of the implementing regulations talk about both sexes, each sex. It's very clear that a binary, male and female, is the whole foundation on which the entire statute rests. But no matter for the Biden administration, we have now seen an expansion that is likely going to have repercussions for years to come. And it's not just the expansion of this gender identity. It is also the removal of the due process protections for individuals accused of sexual harassment or sexual assault, things like the right to call witnesses, the right to be represented by counsel, and the failure to use appropriate preferred pronouns is now sufficient to mount a Title IX sex harassment claim.
Okay, let me back up to the basics of how Title IX operates when it comes to various institutions across the country. What this means is anywhere that receives federal funding would have to abide by these rules. Is that correct?
Absolutely. And let me tell you, that could be as little as $1, and it could be received directly or it could be received indirectly. And that's just about every institution in the country. Now, there are a handful of schools that accept zero federal funding whatsoever. But generally, even if you take a child on, let's say, a reduced lunch program, or you admit a student to your college on a Pell Grant, or you take somebody who has borrowed through student loans from the federal government, you are subject to Title IX, whether you like it or not. These rules are going into effect and will be fully operational as of August 1st of this year.
So beginning August 1st, if you have a student who receives a federal loan attending your institution, you will not be able to ensure that bathrooms are separated between men and women any longer at your school.
Absolutely. That's correct.
Okay. Additionally, locker rooms will follow the same rules. Men can now use women's locker rooms in these institutions. And in fact, they're so protected that if you stop a man from entering a woman's locker room, you could be subject to a Title IX violation.
That's exactly it. And then what happens, Vince, when you have biological women filing claims for discrimination, and they are essentially being graded against biological men on their discrimination claims. So if a man comes into a woman's restroom and she files a complaint with the Department of Education for sexual harassment, sexual discrimination, How will the department determine whose claim wins? They've actually set up a rule that naturally conflicts with itself because there are people, well-meaning and very rational, intellectually honest people who recognize there are only two sexes. They are distinct, they are immutable, they cannot be changed, and someone's subjective gender identity cannot trump what the Supreme Court has recognized as an immutable characteristic like sex and race, as it always has.
Does this additionally impact sports broadly?
So it's interesting what the Biden Department of Education has said. They have said there was a separate rulemaking taking place. I was on a call with Catherine Lehman, Assistant Secretary for Civil Rights today. She was asked a direct question: is the department moving forward with the separate athletics rule? She did not answer the question. Instead, she simply said, we're very excited to be releasing today's rule. Well, I'll tell you, there are 31 references to athletics in this 1,500-page rule. And they mention the failure to discriminate, the prohibition against gender identity discrimination in extracurricular activities. So quite frankly, it's a bit of a head fake. They've told us that it doesn't include athletics. You know, we have a separate rule for that, but they won't tell us if the rule is moving forward, and they won't explain athletics.
My mind was just rattled by you explaining all this because I was reminded of, I think I saw a headline in the last week or so that the Biden administration is looking to bury their determination about sports until after the election. Because
that's exactly it.
Because obviously this is very politically untenable. But most people can very easily see why it would be a very bad idea to allow men into women's sports. So they're trying to hide that detail until after the election. Do I have that right?
100%. And I'm going to tell you, it polls terribly for this administration. 70% of the American electorate, no matter what the party, does not want gender identity to determine sports participation. They want sex-separated sports, and why wouldn't they? There are physiological, obvious distinctions between males and females, and that is why it polls horribly. I think they want to pretend they never attempted to engage in this, but they're still moving it in through the back door. And as soon as we see a complaint from a biological male who is denied participation on a girls' lacrosse team because of his gender identity, and that complaint's filed with the Department of Education, I can guarantee you who's going to win.
I'm not asking you to make a spiritual assessment, but this is demonic to me. What I'm watching.
100%.
And
100%.
What is the motivating factor that underlines all this? Is it as simple as like special interests? What is making them embrace this insanity so rampantly?
You know, that's such a great question. I think it's a function of a number of different issues. I mean, the president from day one, his first executive order in office as the sitting president of the United States was to issue an executive order to every federal agency, HUD, DOJ, HHS, education, to all interpret sex to include gender identity. Well, when your commander-in-chief directs his federal agencies to manipulate law and federal regulations, by the way, over 100 of them that contain sex discrimination prohibitions. That is a president with an agenda. We also know that the, quote, gender-affirming medical care industry is a $3 billion a year industry. Right. There is the medical community that wants these things to pass, cultural elites who have bought the nonsense that sex is the same as gender identity, and celebrities for whom this particularly vulnerable population of adolescent kids looks to for their guidance. This is a significant sort of whole of culture movement that I think is very well funded and very vocal, and it's got a lot of Americans running scared.
Yeah, they're normalizing the abuse of children and the betrayal of women, and they dress it up under the guise of decency that this is what's supposed to happen. You mentioned, I want to go back to kangaroo courts now for a moment. We all remember like the Duke lacrosse case or any number of false accusations leveled at men on college campuses and just accusations broadly, the way that they're done. The left has advocated for years for due process to essentially disappear entirely, and that for a female accuser to be reflexively believed and for the male's life to be destroyed. What's the effect of today's Title IX ruling? What happens?
Oh, well, what we do is we go back to what's called the single investigator model, okay? And these are young, often recent college graduates themselves. I have to laugh. One was actually in my Twitter feed today when I was breaking down the different portions of the rules. This is an individual who was just appointed Title IX coordinator at an ostensibly religiously affiliated institution, who identifies as a gay, genderqueer Latino man, and he's probably all of 25, maybe 30 years old, so not that far out of grad school himself, with no direct experience enforcing Title IX. And again, I have to laugh because these are people who are literally determining the future of these individuals' academics and their career possibilities. Be accused of sexual assault and sexual harassment and sexual misconduct without the opportunity to, let's say, introduce evidence or be represented by counsel or to cross-examine, all of which have been gutted. You've really returned to a guilty until proven innocent standard. And what's more, they have actually taken what the previous administration did, which was the clear and convincing evidence, and they moved that standard down to the preponderance of the evidence, which we like to call the 50% rule. So it's really something that promises to potentially upend the lives of real innocent people up, down, and sideways.
You kidding? I know this is not specifically the topic of this interview, but on this issue, the way that sexual assault is handled, for instance, on college campuses, you ever notice the left doesn't want courts to litigate this? They just want there to be some campus tribunal that handles it. Yeah. And meanwhile, with the military, they want to remove the chain of command and say, no, commanders can't handle sex assault cases. This needs to be handled by local prosecutors. What's the deal there? Why are they opposed to the military handling it, but want universities to actually run tribunals about sexual assault?
Well, that's exactly it, because when you involve a true criminal procedure, then you get the automatic due process protections that the Constitution secures and case law provides. You have the right to an attorney. You have the right to remain silent. You have the right to cross-examine. They don't offer these opportunities. So we're returning to what many of us who are conservative legal scholars call lovingly the kangaroo court system. One person acts as judge, jury, and executioner, and literally you have such a diminished right to be able to counter whatever the claims are that are being offered by the accusing individual, that your guarantee is essentially that you're walking in with this imprimatur of guilt, and you have to prove that you're not actually guilty, but not given the tools to do so.
Back on this issue of Title IX and the way it's going to impact men and women at school, you mentioned that schools are now going to be forced to use, quote, preferred pronouns for the students and faculty, I guess, who are at these institutions. Does this mean that if a student doesn't use the, quote, preferred pronoun for another student, that a school is going to be more prone to punishing that student now in order to make sure that they don't run afoul of Title IX?
That's a great question, and the short answer is yes. In fact, again, on the stakeholder call where I listened quietly to Catherine Lehman explain sort of exact parameters of this particular rule, she posed a direct question about misgendering. And she said, yes, there are going to be instances where the failure to use an individual's preferred pronouns is going to rise to the level of sexual harassment under the Title IX regulation. That's it. It's right there. That's exactly. So I'm thinking of all of these individuals who are walking in with, for example, moral objections or conscience objections or
religious.
For God's sake, scientific. That's exactly it. Scientific, religious objections to being forced to say something, which, by the way, the Supreme Court has just held in the 303 creative case versus Elenis from last term. You can't be compelled to create or force or speak a message that you don't want to communicate. It is patently unconstitutional, but there you have it from the Secretary of Civil Rights' actual mouth.
I mean, just to be more specific, I mean, and you are, this is anti-religious bigotry. If you're a Bible-believing Christian, you find in Genesis that God made the man and woman, and if you hold that belief within these institutions, you are going to come under, you'll be in trouble based on these Title IX changes. And my impression was that the First Amendment of the Constitution outpaces any demented left-wing political priority.
Absolutely. In fact, what the Supreme Court held in 303 Creative was no law is immune from the bounds of the Constitution. So sorry to break it to you, Catherine Lehman, but it's really not a legal provision to say that you can force an individual and lip service to the First Amendment, Vince. They really do. They try hard to sort of, square the round peg, but she has to admit that the rule is going to be patently unconstitutional because she admitted in an open forum with about 100 other stakeholders listening that these were going to be sufficient for sexual harassment claims.
And this madness begins officially August 1st.
It is in place in every sort of receiving public institution for, again, $1 is the standard, directly or indirectly, August 1st of this year, conveniently, for the beginning of the new school year.
Sarah Parshall Perry is a senior legal fellow at the Heritage Foundation. Thank you very much for your time today, Sarah. Good to have you. Hope to have you back again soon so we can untangle all of this.